President Mahinda Rajapaksa has sought an opinion from the Supreme Court as to whether there are any constitutional impediments preventing him from seeking a third term in office. A letter addressed by the Registrar of the Supreme Court to the President of the Bar Association of Sri Lanka notes that the President has requested the Supreme Court to provide an opinion on or before the 10th of November.
The letter addressed by the Registrar of the Supreme Court to the President of the Bar Association also notes that the membership of the Bar Association will be able to make written submissions on the matter until 3 p.m. on the 7th of November. As per the letter, the President has posed the following questions to the Supreme Court. As per the letter, the President has posed the following questions to the Supreme Court.
Court. A. Whether in terms of Article 31, 3A(a)(1) of the Constitution, as amended by the 18th Amendment, I, as the incumbent President serving my second term of office as President, have any impediment after the expiration of 4 years from the date of commencement of my second term of office as President on 19th November 2010 to declare by proclamation my intention of appealing to the people for a mandate to hold office as President by election for a further term, and B. Whether in terms of the provisions of the Constitution as amended by the 18th Amendment, I, as the incumbent President serving my second term of office as President and was functioning as such on the date of the 18th Amendment was enacted, have any impediment to be elected for a further term in office. Unquote.
The Registrar of the Supreme Court also notes in his letter that requests for written submissions from the membership of the Bar Association of Sri Lanka have been made on the direction of the Chief Justice.
වැදගත් කරුණක් පැහැදිලි වෙනවා අපි මතු කරපු නීතිමය ප්‍රශ්නවල වැදගත්කමක් තියෙනවා හරයක්.
This shows that there is a degree of importance to the legal points that we raised. He has accepted that there is a premise to the arguments that we have made. In truth, this is legal advice that he should obtain from his private counsel. We see the referral of this matter to the Supreme Court as the misuse of presidential power and the misuse of Article 129 of the Constitution. This will have several unfavorable consequences. We brought up this argument noting that at the suitable time, that is when President Mahinda Rajapaksa makes a proclamation that he is seeking a mandate, we would go to the Supreme Court, challenge the validity of the proclamation and seek an injunction on the Elections Commissioner, noting that it is illegal to call for an election based on this proclamation. This referral has completely blocked our legal right to do so. So this determination will be given by a 5-member bench of the Supreme Court, and in order to go beyond that, we will have to seek a 7-member bench. I see this as a cunning undertaking to prevent such a thing from happening.
ඊට අභිභාවයන්ට 7 දෙනෙක්වත් අඩු වශයෙන් අවශ්‍යයි. එතකොට එවැනි අවකාශයක් සම්පූර්ණයෙන්ම අවහිර කිරීමේ සූක්ෂම වැඩපිළිවෙලක් ඇසිට මම මේක දකින්නේ.
නාම යෝජනා බාර දෙන අවස්ථාවේ ඒ අවස්ථාවේදී මෙවැනි නඩුවක් දුනොත් අනිවාර්යයෙන්ම සිදුවන්නේ ඒ නඩුව නිසා එම
When nominations are called for, if such a case persists, then what could happen is that nominations could be extended. So what I see is that the President has decided, as per the powers vested in him by the Constitution, to refer this matter to the Supreme Court before such a situation arises and give others too a chance to make submissions before the court gives an opinion. I do not see this as a major problem. It is a very simple matter. In the end, the final decision rests with the Supreme Court. It would have been good if more time had been granted for the stakeholders to make written submissions, but at the same time I believe that since this is a topic that has been discussed on the political stage and elsewhere for an extended period, the stakeholders will be able to make their submissions at short notice. This is a legal issue based on 2 provisions of the Constitution.